Hello, hello, hello. You dostate.
Yes.
Adjournment request, if any, from item number 1 to 12.
Where?
One of the, sorry, my lord, I am begging to for mentioning of a matter is item number 7 today, my lord. My lord, the learned senior counsel is appearing outstation counsel, my lord, on remote, my lord. And as well as, my lord, we have filed an IA, my lord. And subsequent developments are also there, my lord. We have brought on record all those things, my lord.
Who is appearing in this matter?
Lord, Mr. Salman Khurshid.
Okay.
My lord. So, my lord, may I pray? He has requested my lordships to pray for a date, my lord, 10, 12, or 16th of March, any date.
16th of March.
My lord.
You want on 16th of March specifically?
My lord.
Why not? Yes, the state. Would they have any problem?
That Padmini, my lord.
As prayed for on behalf of the petitioner, after having obtained consent of the counsel for the state, have you obtained consent?
My lord, I have informed, my lord. I have informed.
Let this matter come up for consideration on 16th of March,
Along with the IA which we have filed today. my lord.
along with the IA which is said to have been filed in the registry today.
Fine.
All.
Oblige, deeply oblige.
Item number 9, I petition in person in this case. I received an affidavit in opposition yesterday evening, so I need to file a reply.
This is with respect to SR revision. You are not a lawyer, you are a lawyer. But you are appearing in person. As prayed for on behalf of the petitioner who appears in person, let this matter come up for let this matter come up for consideration on give a date after in April. Will. Chalo.
Second appeal.
This matter is become infructuous.
Which one?
This matter, in fact, the lordship,
Nine.
this matter is related to.
Let him come on that day and say, what do you have to do? Therefore, I have kept it in April. Yes. Louder, madam.
As for the introduction of the petitioner,
We have not been able to hear you. आप थोड़ा सा जोर से बोले. Don't worry. आपकी prayer को allow करूंगा. बोलिए तो सही.
introduction of the petitioner, the matter be kindly withdrawn.
You want to withdraw? अच्छा ये transfer है. He had been transferred to Jorhat or someplace. Huh? You have no idea. What is your name? नाजनीन. आपका नाम नाजनीन है. क्या नाम है आपका? हाँ? Full name?
Is not on record.
नाम लिखाना जरूरी होता है ना? Because you are withdrawing the application. Otherwise, we'll say that on किससे instruction? Who gave you the instruction to withdraw? D. Sharma. D. Sharma gave you the. Ask her, has she understood my query? D. Sharma. MS so-and-so, जो भी नाम बताया, MS so-and-so learned advocate. On instructions from Mr. D. Sharma, D. Sarma, not Sharma, D. Sarma, the advocate on record, seeks permission to withdraw this appeal. Dismissed as withdrawn. Doesn't matter, she's withdrawing. There's no occasion for you to come. Right. Yeah, his presence, the counsel for the state's presence also. All right.
From item number 13 to 19, adjournment request.
Contentious.
Item number 16, my lord.
15.
15. That's number 12. Newly entered 12, they're filing an affidavit in opposition. So, my lord, I had prepared my reply, but only because of some problem, I couldn't contact my client.
Number?
16.
Adjournment slip has already been circulated. All right.
Already, my lord, submitted my adjournment.
Adjournment slip has been circulated. Sent to the other side. Sometime in April.
Well, I beg to mention item number 14 of today's list, Malad. Item number 14, Malad.
14.
Yes.
Hmm.
Malad, in this case, Malad, the learned senior counsel is supposed to appear from Shillong, Malad. He has some problem today, Malad. He could not come. Letter may be taken up after.
On hearing days, it's very difficult to, grant adjournments. There are few matters which are posted for hearing. If you take time, then the list would collapse, no? But anyway, you are challenging some of the provisions of Assam Cattle Preservation Act, no? Yes, man, what other thing? You're testing the virus of particular provisions of the act. Question it. We will answer. Either we allow your prayer or we reject your prayer.
Last occasion, Malad, my advocate.
And
Malad,
that's,
has taken time.
we have been giving time to others on asking, so we will give time to you also, but then you don't ask for a day or two adjournment. We will post it for April end. Like here, as prayed for on behalf of the petitioner. After having obtained, you consent?
Yes.
After having obtained consent from so-and-so, re-notify, end of April. Yes.
Item number 18.
Anganwadi worker. Why are these matters being, huh?
For 3 weeks.
For?
For 3 weeks.
Forget it. We will give you 6 weeks. As prayed for on behalf of the appellant,
May.
let this matter come up for consideration. 6 weeks.
If May.
Hmm? No. You, who appears for the other side in that matter? Have you obtained consent?
Government.
There's no private
18.
respondent here?
18. No, only government.
There's no private respondent. Boda, let's see if there is a private respondent. In that case, huh? No private respondent. Any interim order?
Respondent number 7 is private respondent.
And interim, any interim protection? Subsisting? Arey, unse mat puchiye na, I'm asking you. He doesn't know, he doesn't have a file, he's making a mention out of a chit.
It is come from single bench, your civic actually.
Let us see. कोई interim नहीं है तो हम May में करेंगे.
Because
Unnecessary.
first time in the beginning.
Says liberty is given to respond to file an application from the May end. Yes.
May end. May.
Lordship, praying for listing of a rate appeal, Lordship. Any date next week, Lordship?
That's true. Once it is listed, you will take time.
This last
We've
question.
just seen what has happened.
Yes, Lordship.
What is the urgency?
Urgency, the matter has been listed, Lordship, 5 months back, Lordship, and it has not been listed yet. And subsequently the.
Next week. That's Lordship. Yes.
My lord, I am also praying for listing of a petition tomorrow, my lord, due to urgency.
What is the urgency?
My lord, the petitioner has been handed with a punitive
It
transfer.
has punitive?
Yes, transfer, my lord.
So transfer is not punitive always.
My lord, here, my lord, they, that authority.
That goes before a single judge.
No, it is coming from the CAT. The CAT has on irrelevant consideration dismissed it, my lord.
CAT has dismissed your petition. When was the transfer order made?
My lord, it was made on, my lord, 21/7/2020.
First to continue.
20. And you have not joined that post.
No, my lord, you know, because I am a newsreader and translator in AI and Gauhati.
We don't know. Is there a judicial order
Yes, yes. it was
staying the order of transfer?
it is stayed.
All right, not tomorrow. Next week.
I have been already relieved, my lord.
So you have already been relieved, so therefore there is no urgency. Next week.
March, 2nd March.
And come with the judgment of Shilpi Bose.
Because when you transfer to Port Blair, there is
We don't know, we'll see. Unless there is a statutory prescription against transfer, or it is absolutely malified, punitive, or on considerations which ought not to weigh, will not interfere. Anyway, we'll see.
deep level.
This is a writ petition against armed force terminals, was filed in the chamber, yet to listed.
Next week.
Next.
Is it with respect to disability pension? So let the Supreme Court decide, then otherwise, list it.
That I mentioned for listing of immediate appeal hardship. In this matter, Lordship, petitioner service, provincialization of service was withdrawn by the concerned authority by the order, speaking order dated 20/02/2025. And afterward, appellant filed a writ petition before the Honorable Court. And this writ was filed on 28th of February 2025. And afterward, on May 1st, 2025, his petitioner's writ petition was closed without going to the merit.
It doesn't tell us anything about urgency, but then since you have come after looking at the file, we'll fix it. When do you want it? Tomorrow is not possible.
Day after tomorrow.
Next week, Monday.
2nd March.
But without any urgency, we are listing because you have labored, you have found out, right? Always come, young advocates, if they come for mentioning, they must have the file with them.
Daily list for orders item 1.
ये तो review पढ़नी है. Yeah, Mr. Khatniar, what is the status of review?
No, it is not. It is listed. I have made effort to. But I have made application for the registry also. Till date,
Review, ऐसा करो, you just make a note of this. Tell the filing section that it should come on the administrative side before me. We will keep the review. Now, in that case, we'll have the review listed along with this. Correct?
Yes, my lord, limitation petition is also there, madam.
So let us list the review. We'll have all this listed. Now, unless I pass an order on the administrative side, it shall not be listed. Because the order which is sought to be reviewed is by the predecessor Chief Justice and some other judge.
Yes.
So let's see what is to be done. Now I'll have it listed before this court and we'll link it with this, Master Chief. Not necessary. Doctrine of necessity, or we will do whatever. Ask the registry to.
That application is already filed before.
That application has been filed. It should come before me in the administrative side. Okay, let this matter be listed. At the request of the parties, let this matter be listed on. We will place it in the second week. एक week के बाद दूसरा week.
Blind.
11 March.
And remind me.
Yes,
इस
sir.
पर क्या करना है.
जी. Item 225.
Subsequently, their service regularized but not given the.
अभी आइए नहीं क्यों रहा है? Why fraud us?
Stay of.
No, वो तो नहीं.
In this case,
What is IA for?
my lord, IA was initially for staying the process of promotion to the post of headmaster.
Promotion or a recruitment? Promotion.
Promotion
Huh.
to the post of
Have
headmaster.
you been prevented from applying for it?
We have not been allowed because we are the contextual teachers. We have put to challenge this.
And your services were regularized when?
It is for regulation, we have put to challenge this.
No urgency. No, we are not going to stay the process.
It is.
It was up till now.
it
What
is-
we intend to do is that we will have your main writ petition listed,
Yes.
correct?
And we have filed the reply also to the.
Is still pending, so we'll have to ask the director.
Along with the IA. No, no, we'll say.
We have filed the.
Let these set of interlocutory applications be listed along with writ petition number, writ WPC number 3159 of 2025 under the heading admission. Give a date of next week, Tuesday.
Thursday,
That's a better way.
8th March,
Can it be after 9th March? Madam?
9th March.
After 9th March. You respond in the meantime.
We have already filed our.
All right.
We have also replied, my lord.
But in my.
10th.
We have not filed an affidavit.
Then-
At least 5 months.
We will take that affidavit. We will make him concede that the same affidavit will hold true for your case also.
Let him consider my.
On the day when we decide it will become.
Sir, that,
I'll file.
much of.
12th March. Item number 6,
Yes,
Also on the last two petitions, Lordship had directed the department to take a fresh call on the
did we?
transfer.
Let us see the order.
18th of December.
18th of December. Please read the order aloud, whoever has it.
The appellant has questioned the judgment dated 2/12/2025 passed by the learned single judge in the court in WBC such and such whereby the transfer of the writ petition or respondent number 1 hearing from the post of registrar, Labour Court Gauhati to the post of registrar Industrial Tribunal Deliberation has been set aside and a fresh order of transfer has been directed to be passed by the competent authority. It appears that the order transferring the respondent number 1 was questioned on the ground that it was basically issued to accommodate the appellant who had made personal request which was acceded to. However, while effecting the transfer, the respondent number 1 to disturbed from our Gauhati location. Mr. S. Dattal, an advocate for the appellant, however, questions the judgment impugned on the ground that the transfer on personal request is not taken. And hence, once the request was acceded to, we should not have been ordinarily interfered with merely on the ground of such transfer not being in public interest. By the impugned judgment, a fresh order of transfer is now required to be passed, accommodating both the appellant and the respondent. Let such order be.
Show us from the impugned judgment, where is this direction?
My lord, your worship will find.
Both are
Read it
judicial
through
officers.
The penultimate paragraph. At, my lord, paragraph 118,
Which paragraph?
paragraph 20. From the judgments recorded above, it is clear.
No, no, please go to paragraph 21. Please read paragraph 21.
Paragraph 20, yes, ma'am. Under such circumstances, while this court does not dispute with the proposition that the transfer is an incident of service and ordinary
Incidents.
interference with transfer order ought not to be encouraged in judicial review, the peculiar facts which have been placed before the court reveal that the impugned transfer order dated 26/2025 is not a transfer order issued in public interest. Such interpretation cannot be given to a transfer order which was issued or initiated on the basis of a request made by the individual officer. Ordinarily, when a transfer order is made on request, the seniority of the
No, no,
person
no,
concerned
yes,
and the
sir,
place
yeah,
of
yeah.
question where the choice is indicated.
No. This principle is not applicable here. Anyway, then the fact remains that the reason placed by the court of depart do not inspire confidence to return a finding.
Accordingly, the petition stands allowed, impugned transfer order dated so and so stands interfered with and set aside.
No, but where is this? How we got the impression that both should be accommodated?
No, that is. No, thereafter, my lord.
By the impugned judgment, a fresh order of transfer is now required to be passed, accommodating the appellant and not both of them at Gauhati, but let us see where. Now, where is that decision by the government? Mr. Pathak is appearing.
It seems it is yet to be taken, the decision.
How do you know? Who appears for the government? But where do these government advocates disappear at the nick of the time? There's nothing else that we will do. We'll go by your decision making transferring, and if possible, both of them should be accommodated. That's all. If you give such a deadpan expression, MS Bora, what we will do? At least ask. Let us conclude this, no, today. Mr. Advocate General, good that you came. Now, there are certain cases where one word from the state and the issue is resolved. So you'll have to take care. I mean, we said there was some transfer order. 2 persons were transferred. One as a registrar, one as, I mean, of course, they are not judicial officers, but under the institution of the
Legislative.
yeah, under, some was in labor court, the other person was, a male person was transferred from Gauhati to Dibrugarh on his request. Dibrugarh to Gauhati on his request. Now that required displacement of 1 person from Gauhati. So a lady officer was chosen and she was transferred. Now she filed a case. The single judge says that this order transferring somebody from Dibrugarh to Gauhati was not in public interest. It was at his request, and therefore direction for passing a fresh order. We added, we made a superimposition in that order. We said that now a fresh order is required to be passed, accommodating both if possible in Gauhati. So therefore it was awaiting that decision. We have no idea what decision has been taken. This order was passed on 18/12/2025.
Anyway, Lordship will give me 10 days time, we'll pass an order.
As requested on behalf of the state, let this matter come up for consideration on Thursday. Just this. Now, please tell your government advocates that these are issues where not much, no, there is no uphill task defending. We don't say that you don't transfer him or transfer him. Both the transfers were found to be bad. Therefore, accommodate both of them, and if possible, if not possible, please send them out. There is no difficulty. We are not going to interfere.
The system should work, Lordship. There should not be any vacancy.
Subject to vacancy, subject to your ease of, everything yours.
Administrative access.
But something has to be done.
We'll do it, Lordship.
Yes.
They come on 11th of March. Lordship.
No, the difficulty is that both Mr. Chaudhary and him, and Mr. Who is that person who are? Mr. Alam, both are facing difficulties. One is a lady who has a problem with her mother or somebody.
Both of their salaries have been stopped since June last year.
So decision has to be taken, no?
Lordship, in that case, Lordship will kindly give me time on 1st of March, let the matter come up. We will take a call.
On 1st of March.
I may not be here, but I'll ensure that the decision is.
All right. 1st of March.
First holiday.
What is the holiday?
First is a holiday.
Monday, second.
Second of March.
Second. The first is a Sunday.
Yes.
No, you can go after 10 days also. Nothing is
In
going to
that
happen.
case, then 11th of.
11th of March. Some decision has to be taken, no? There's no arguments on merits of the case. A transfer order has to be effected, and if possible, both should be accommodated. That's all. Subject to vacancy, subject to your convenience.
Deeply applied.
All right.
Item number 8.
ET.
Yeah, please, my lord.
Yes.
Lord, in item 8, my lord would recall, this is the matter where, my lord, the rules were never amended and my degree was delayed by almost a month, my lord, because of the university. And my representation has been pending with the government for 2 years, my lord, that till date don't take a decision.
Mr. Counsel, we don't recall anything.
My lord,
You'll have to say afresh.
My lord, my lord, my
We
lord.
don't recall, because have we passed any order?
Yes, twice, my lords, have passed orders, my lord.
No. Any introductory order with respect to the facts of the case?
The first
No,
order.
we haven't. No, we haven't.
Very well,
So
but I'll
you-
recapitulate.
So you just argue.
So what has happened is, my lord, the learned single judge has dismissed my writ petition on the primary ground of delay.
No, what is the case?
The case is this, my lord. I had applied for a teacher's post in the government recruitment, my lord. And the eligibility I was satisfying, but what happened is, my lord, that as on the cutoff date or the last date to apply was November 2024, 20th November 2024.
Yes.
I had given the examination, my lord, and my degree was delayed by a month for getting the minimum essential qualification.
Minimum essential qualification, TET.
TET plus TET is the exam, my lord, and B.Ed, my lord. I had to take a B.Ed degree, Bachelor in Education. Thereafter, what happens is, my lord, that I write to the university gave me a date sheet wherein they said that they will give me the result, my lord, prior to the last date of the exam, the last date of application in the state of Assam. The university I keep following up, my lord, but my results are delayed for whatever reasons best known to the university, which is beyond my control. Therefore, as per the rules, my lord, as per the recruitment rules, if there is a relaxation required, I can submit a representation to the government, my lord. I submit a representation to the government well within time. The representation given in November of 24, we are in February of 26, till date has not been decided. Meanwhile, my lord, people less than me on merit have been appointed in the recruitment, which are much lesser on merit. I say this point very consciously.
That is not very important. You say,
Yes.
were you ousted from the
I was
consideration zone?
I was
Why?
ousted
Because you did not supply the certificate.
I did not
The
supply
eligibility
the
certificate.
as on the date of applying. So there was
So
a difference.
therefore, don't jump the queue.
Yes.
Now, first you say that you were not considered. Therefore, people with lesser marks,
Indeed, my lord.
you were not considered. Now, what did you challenge then?
My lord, so this is the second round of litigation. In all fairness, I should say, in the first round of litigation, my lord, what I challenged was that whether I should be the entire advertisement was put to challenge, saying that because the advertisement does not give a relaxation further, my lord, and there is a fault not of mine. Therefore, there should be an extended date of the advertisement. That is the first round of litigation. I did not talk about
that litigation would have been rejected.
That litigation is rejected
Because it is not backed by any principle of law. What you should have done.
Indeed.
See, everybody becomes wise in the hindsight.
Indeed, my lord.
So therefore, we are in a position to tell you that your prayer should have been for a direction to the recruitment agency to consider your case and allow you to be within the zone of consideration.
Indeed, my lord.
Perhaps that would have been much better. You did not do that. You questioned the entire advertisement. Therefore, it was gone.
Yes, my lord. And therefore, it went up to the Supreme.
If you don't choose your words properly, if you don't have your prayers well defined, you run the risk. So that litigation is gone. Then what happens?
Went up to the Supreme Court. Supreme Court SLP is withdrawn, my lord. Thereafter, a writ petition is filed now for the correct prayer on this ground that two things. One, there is a representation given. The representation is admitted by the government. The representation was given well in time. The rules of the recruitment prescribe a representation that if anyone wants a relaxation, you can give a representation. We will decide it. Whether positive, negative, that's a different thing. The representation was given well in time. So the writ petition was filed with two prayers. One, that please let them decide my representation because my representation is not decided in positive or negative.
Just a minute. So you're Mr. Kalra, yes.
Indeed,
Mr. Kalra, so that representation which you had filed in the year
2024, my lord.
So that went unresponded till the recruitment. And what was the stage at which you filed that writ petition?
Yes.
Second writ petition?
The second writ petition was filed, my lord, when the appointment letters for the ongoing.
So therefore, the decision making with respect to recruitment was over, so far as your subject was concerned.
I will slightly put it in a different way.
No, we are not concluding it just by these preliminary questions.
Yes.
We just want to have those anchorage points, clearly spoken, and then you can argue.
But the appointments were not given. The appointments were not given.
When you filed your second writ petition, by that time the recruitment process was over.
Not over, my lord. The appointments were not given. There were no persons appointed.
Appointment letters were not given, but select list had been prepared.
Select list had to be prepared. It was not prepared. Had to be prepared.
All right.
Preliminary document verification was done. In the document verification.
What happened there? Then what did the single judge say?
The learned single judge rejects my petition on two grounds. One, my lord, the primary ground they take is delay. That because I have come after almost 18 months of filing the representation, therefore the petition has to be dismissed on the ground of delay. Second, they also appreciate my fairness because I talk about the entire litigation which was done in the first round. Second, they say because the government has not decided, this stage we can't do anything. We missed the bus is the second point that the learned single judge says. Now, my lord, on both these aspects, on the day when my lord issued notice in the matter, I take my loss to those judgments. In writ petition specifically where representation has not been decided, my lord, the delay will not come in my mind. Because if at all, my lord, it is a recurring cause of action Even now, my lord, to my fortune, the government in their reply before this honorable court, which they have filed today, my lord, they are accepting my representation. They are saying, yes, there is a representation, but they have not countered to say that whether we have decided or not decided. They are not disputing my representation. And it is not as if I have given a representation out in the air. The rules permit that I can give a representation. That is what the statutory rules say. Further, my lord, the advertisement also had a clause. This is something which is the heart of the matter, my lord. The advertisement also had a clause that if I want a relaxation, then I can apply 7 days prior to the last date. I can give a representation 7 days prior to the last date. The last date in the advertisement was 20th November 2024. I had given the representation on 11th November 24, 9 days prior to the last date. So the advertisement also had the clause. What the state has done is, my lord, they withdraw that clause of the by a corrigendum. That is also a subject matter of my writ petition before the learned single judge. But fortunately, again, my lord, the second answer to this is that in the counter that they have filed now, they admit that the rules were never modified. So irrespective of whether they take it out from the advertisement, that will not be consequential against me because the rules never stood modified. The rule even today stands. And the rule says that a relaxation is possible, we can give a representation. So therefore, what I'm saying is, my lord, that because things were beyond my control and there was
That's
some...
all right. We have followed that.
Yes.
Because you had passed the interview, the university which had to give you the certificate that kept on promising, but it never came before time. You must have received that now. By now, you must be in receipt of that.
No, my lord, I'll just add on to that. So from the application till the document verification in the recruitment, there was
That's all
6
right.
months.
But the difficulty is this.
Right.
By the time all this happened, and when we are hearing this matter today, the train has already left the station. Now, whether there is vacancy, can we, on this ground, Mr. Kalra, I put this question to you,
My lord.
because you may be holding brief for your clients, but you are also responsible to the court. You are an officer of the court.
First responsible to the court.
No, equal responsibility. Your responsibility is for your client also.
My lord, my lord.
But responsibility towards court is no less.
My lord.
Now tell me, on this ground, can we destabilize, can we disturb somebody if the post is filled?
My lord, I'll directly answer that. Not even
Now,
today.
what could be done for the state to expiate for their lack of lack of sincerity in deciding about representation, especially in matters of recruitment? Question is this. Now, which legal principle will tell us that on this ground, once the recruitment process is over, posts have been filled, we turn the clocks of the hands of the clock back? Can it be done now?
There are 2 answers directly on this.
Yes.
First answer is, as on the date of the impugned order, my lord, the appointment letters were not given. That's point number 1. Point number 2 is, as I argue today, my lord, there are at least 20 times more posts than the petitioners here, which are still vacant. 20 times more posts. Third thing,
were those posts advertised? See, availability of...
They were advertised, they're not been fulfilled. They're not been filled. They're still vacant posts. They're still vacant posts, and therefore, my lord,
Just a minute, Mr. Kalra, you have to be very specific. Then we'll immediately put this question to the state. Now, let us see how effectively that injury could be resolved. Though we are not doing any panchayati here, but as of now, we have not been persuaded to think that you have a right has accrued to you for us to pass an order or differ with the learned single judge. But let us see how best can you be healed, can your wounds be healed. Now, you have to tell us that the posts which were advertised, if those have remained vacant because of lesser number of successful candidates or people not joining, then situation would be conducive for any observation in that regard, which saves you, which helps you. Otherwise not. There may be many posts which are required to be filled up. But if those posts were not advertised in this chain of recruitment process, then perhaps the door is shut on your face. If the same post, in the same advertised posts, there are vacancies, we might ask them to consider that also in a different way. We'll hear from them and then we decide. Yes.
Two answers to that. First answer is, my lord, in the total number of vacancy, the posts that were advertised initially in 2023, there are posts vacant from that, as is what my instructions are. That's point number 1. Point number 2 is the reason for the post being vacant. Of course, some of them are people have not joined. some of the, it is that people, because there's been a subsequent advertisement also. After this advertisement, there's been a second advertisement. Some people who have been selected here have joined there.
Did you apply against the second
But
advertisement?
most of us are age barred. Most of us are age barred in the subsequent advertisement. We couldn't have applied in the subsequent advertisement. And therefore, my lord, carefully, they have not mentioned a word about in the reply here that there is no post vacant. So therefore, the controversy, I am so grateful that my lords are looking at the solution of what could be done to this. Therefore, the controversy could be resolved. We have already filed an RTA, they have not responded. But we have information that I've been instructed on that all the petitioners.
That information is through your clients who are desirous of getting into service.
Indeed.
That could be lopsided. That
Yes.
information.
So therefore,
could
I have
be
a suggestion to make.
Let us see. Mr. Khatniar, you have heard the discussion between the bench and the lawyer. Now, are there what is the reason for your not disposing of the representation preferred by them? You could have said no. We want those certificates. I don't know which institute are you talking about. We are only concerned with black and white document before us.
Yes.
If it is not there, go.
That's the law, madam, but
That is not the law.
somehow.
The law says that you can 7 days before you can ask for a relaxation. Don't just
No,
take the shelter of law, please.
no, I'm not.
Law operates not in vacuum. Law operates with the set of acts.
Regarding that relaxation criteria at rule 31, that is not regarding the educational qualification, because this is an essential qualification. It is an essential qualification, madam. So that we cannot ignore.
No, there are Supreme Court judgments which say that if there is in fact, we have also done it in our judicial appointments.
Yes, madam.
You have to
Yes,
see some judgment from Patna High Court.
In fact,
The degree was not handed over before the last date, but we allowed, and such persons are doing very well in service. Do you have that judgment? We have discussed the entire law in that regard. But anyway, chaliye, that we will not ask you to replicate what happened in my state. Yes.
so that representation was not disposed of, but they have filed writ petition that was dismissed on that ground, madam.
No, forget about court's decision. You did not dispose of the representation. Why?
Because subsequently, madam, that clause, relaxation clause was also inserted in the advertisement, but it was subsequently withdrawn, madam.
But question is that how could you withdraw it after the whole process had begun?
It's not a condition of recruitment, madam. It's a relaxation criteria which was
Or
incorporated.
taking it to a logical conclusion. So some passage which you have in Tej Prakash Pathak's case.
Yes, madam.
We are suggesting grounds to both of the advocates. Why is it so? Why is it so? We are not supposed to act as your assistants, no? You have to advise us.
In fact, in my reply, I have mentioned it, madam.
What?
I will try to distinguish.
Now tell me one thing. Now, if the posts have remained vacant, would you consider them?
That obviously I have to obtain instruction in the.
Please take instructions. Please take instructions and we'll consider. We'll do that. हम उसको नहीं आएंगे. अभी इसको नहीं. Question is that this Baba Sahib Ambedkar University ने कर दिया. They are the last. तक लिखा था. Take note.
Can I just add 30 seconds, my lord, to what I submitted?
Look, there is no right which is accrued to you. In fact, we should not interfere with the learned single judge's judgment unless we find it to be perverse. This is not a regular appeal, it's a service appeal.
Indeed, my
Where
lord.
unless we find it perverse, we will not upturn it. Now, in that case, the court is absolutely right. For representation, you should have come, you shouldn't have waited for 18 months, number one. Number two, this corrigendum would not be changing the rule of the game because it does not attack the basic features of recruitment. Basic features in the sense, the basic tenets on which the recruitment is to be done. Now, they're not asking for any enhancement in qualification or something of that kind, nothing of that kind. They only say that for bringing it to a logical conclusion expeditiously, let us do away with this, relaxation business. That's all.
Just give me
So this is purely permissible under Tej Prakash Pathak's formulation also.
just give me 60 seconds to answer that. Not just 60
No, from 30 seconds you hiked it to 60 seconds. 30 seconds.
Plus, because there are two questions, so 30 seconds each, my lord. 60
See,
seconds.
let you not get into those legalism. We are asking Mr. Khatniar to find out and whether they can consider.
Very well, my lord. Not on legalism, just on fact. Can I just make one statement?
Yes.
Just, Lord, there is another argument which I had, not on law, my lord. That is the doctrine of legitimate expectation. For this reason,
This
in
doesn't
the,
apply here.
But just give me
Doctrine of legitimate expectation doesn't
just give
apply
me
here.
30 seconds, my lord. Just
You
give me
have not entered. See, if you make an argument which is on face of it is rebuffed, then
So just give me
give you
30
another.
Just give me 30 seconds. Lord.
Ah,
In the previous recruitment, what I am arguing today, the state has then done it themselves. I have put that on record.
that's right.
Wherever, my lord, the date was not meeting, they themselves have extended that if you have applied and given the examination, degree has not come, we'll accept you. That is what the state has done. I put that
So
on
they,
record.
Mr. Khatiniar, who represents Education Department, says that now with the change of the course of Brahmaputra River, they don't do it now.
But I will stop
Can
there.
they be forced to do it?
No, my lord, they cannot be forced to. I'll stop them, Lord. I understand what is going on.
That's the only difficulty. If we can't force them under any law, how do we tell them? So we only appeal to their good sense.
Very
And
well.
let's see, because they want teachers, you are qualified. Otherwise, your age is going to expire. You did not appear in the other advertisements. Let us see if they can consider. You don't have a right as to push your case any more than this. Take down.
Just 15 of us. 1-5.
15 of the appellants, the 15 appellants herein have questioned the judgment of the learned single judge dated so and so, passed in WPC number 6409 of 2025, whereby the claim of the appellants have been rejected as being time barred and the appellants having approached the court after a long delay. The appellants are aspiring teachers, state of Assam, seeking appointments as graduate and postgraduate teachers in government and provincialized secondary schools. The concerned recruitment process began with online advertisements issued by the Director of Secondary Education Assam on December 26, 2023, inviting applications for vacant posts. The appellants, it appears, submitted their applications and also well in the teachers eligibility test cum recruitment test. However, they were never considered for the reason, considered for selection / appointment for the reason that they had not been able to furnish a requisite B.Ed degrees one of the essential qualifications, one of the essential eligibility qualifications, for the reason of the institute from where they pursued their in which they pursued their degrees, their B.Ed degrees, namely Baba Sahab Ambedkar Education University, did not hand over the results before the last date of filling up the forms on 20th of November 2024. The contention of the appellants is that realizing this problem, a representation was filed by them on 11th of November 2024 for relaxation of this condition, with the assurance that no sooner would the degrees be given to them by the university, by B.Ed by the institute / Baba Sahab Ambedkar Education University, comma, the same shall be furnished. Full stop. The grievance of the appellants is that such representation was never heeded to, which remained pending consideration, giving legitimate expectation to the appellants that if it is considered favorably, as such request had been acceded to in the earlier recruitment process, comma, by dint of their merit, they would make their way in the government service in Assam. It appears that the appellants rose from slumber only after some appointment letters were issued to candidates who apparently had not performed as well as the appellants. First off, it was at that stage when the appellants questioned the entire selection process, including the advertisement in question, on the ground that it did not contain any relaxation clause, which hitherto always was provided in such recruitment process. The writ petition was dismissed, and the SLP against the dismissal of such writ petition was also withdrawn. First up. Later, another writ petition was filed, but after about 18 months of the appellants having appeared in the examination, that their representations were never considered. The learned single judge, while the impugned judgment dismissed such request. Another issue raised in the writ petition was that after the process of recruitment had begun, addendum was brought about in the advertisement on 15th of March 2024, calling the provision of any relaxation in the terms of relaxation in the recruitment terms, which the appellants alleged before the learned single judge as effecting a provision midway through the process after the game had already been played. Game had already been played. First up, the appellants alleged that this was a change, this was an impermissible change in the rules of the game. First up. While deciding the issues, the learned single judge took note of the contention of the state that the advertisement was issued on 26/12/2023, which was not complete in all respects, and therefore there was one addendum issued on 16th of October 2024. Later, 16th of October 2024. The corrigendum in question was also issued on 15/3/2024, withdrawing the relaxation clause that if any application seeking condonation/relaxation of any criteria even 7 days prior to filing of online application first. The learned single judge therefore was of the view that when the matter was being decided by him, it was already 20 months after such corrigendum had been brought about. After such corrigendum had been brought about. The reliance of the appellants, /writ petitioners, on the decision of Supreme Court in Abhimit Sinha and others versus High Court of Judicature at Patna and others, 2024 7 SCC 262, and Dr. Mazer Meeta Sahai versus State of Bihar and others, 2019 20 SCC 207, was misplaced, and the broad parameters set out in Tej Prakash Pathak, uska citation likh lena, Constitution bench. Tej Prakash Pathak permitted such changes in the recruitment process, even midway, if it did not tinker with the essential qualifications or the modality of the recruitment process, but any change for the purposes of taking the recruitment process to any logical conclusion. We thus find that the reasoning given by the learned single judge cannot be faulted for non-suiting the appellants /writ petitioners. But after having said that, we have taken into account that even till date, as it appears from the affidavit in opposition, there is no statement regarding the disposal of their disposal of the representation of the appellants, though admitting that such representation was filed within time. We also take note of the fact that subsequent to the recruitment process under challenge in question, further recruitment processes have been undertaken and perhaps concluded. But according to the information provided by the appellants, many posts remained vacant. Many posts which were advertised in the recruitment process in question remained vacant, which are required to be filled up. The appellants have lost on their age because of the intervening litigation, but have performed very well in the recruitment process in question. Not selected only for the reason of their not having obtained and supplied the certificate of eligibility, namely degrees of B.Ed, till the last date for filling up of forms. We therefore, in all fitness of things, seek an information from the state whether the candidature of the appellants could be considered against those vacant posts already filled up. And if the appellants otherwise would have qualified, otherwise would have qualified, but for their essential certificate of B.Ed not having arrived on time. Mr. Khatania to take instructions and report back to this court and report to this court on the next date. Re-notify. We give you 2 weeks. This is the maximum, Mr. Kalra, that we can do for you. Nothing
Certainly,
beyond.
Malord. Certainly, I'm more than grateful, Malord. Deeply obliged. I'm more than grateful.
We have passed some judgment. Somehow the other, we have, my brother shows me a judgment delivered by us where we have said that this is no midway. No, we have not done it on that. We are asking them, if you want that, if you want the process, just think about them, we conclude. No, let them say no. We will conclude the process. This is the maximum. See, people come to court for some relief. If something can be given, it can be given.
We are so grateful, Malord. We are deeply grateful.
23rd March.
Your date after 2 weeks. We are not giving you any direction. Just find out if you want the process to be filled up, you can do that.
Very well. So grateful, Malord. Deeply grateful.
I can take.
Yes.
Also, the matter relates to grant of double HRA to the respondent herein, whereby the respondent had challenged the interim order passed by the authorities, whereby his demand for the double HRA was rejected. Thereafter, he went to the honorable tribunal.
Double, what is this double HR?
House rent allowance.
House rent allowance.
There is a policy of the central government that in case an employee is posted in specific areas, northeastern areas or in the union territories, then they are entitled to a double HRA, and if they leave their family behind at the regular station. But that.
Let us see the policy first. Let us see the policy.
Yes, sir.
Suppose one of us would have been in that kind of service where this HRA was admissible. And this place being a difficult posting, the last place of posting would have been a soft posting. Agreed. So I would get HRA at my last place of posting. Now, if I want to locate my family, say in Delhi, and say that now I must get HRA there in Delhi, not in Patna and Gauhati. Is that possible? Which interpretation will tell you?
Absolutely.
This is what has happened in your case.
That is what exactly was our stand.
No. Let us see.
That
No.
was-
Acha, you are for the state.
I'm
You are
the
for the
state.
state.
Yeah. No one has appeared here. so-
No, we are going to set aside the order of the cat. That's a wrong interpretation totally.
That is.
Have you issued notice?
Yes, sure.
I'm so sorry. I thought that the cat had allowed that. Cat had allowed, therefore you had filed.
Yes, sir. Therefore, the authorities, the notice was issued on 5/2025, Your Worship. Your Worship, kindly peruse.
Let this matter come of consideration on the hearing. Okay, when did we do it?
Your Worship, kindly peruse the Lavazema court order.
Just a minute, Ashwin. That's the notice also you have done.
Not just, we do not have his current address. He does not work with us.
No,
He is
because
our employee.
see, we are staying the order passed by.
Stay.
Oh, then paper publication, we should.
Yes, sir.
Right, paper publication. Take the order. We are going to, we are telling you forthwith, we are going to set aside the order of cat straight away. We could have done it now, but then where that person is probably.
Accepted the. But you have to kindly note, 2/9/2025.
All right, but with such clear provision of law, I don't think we should wait, but my brother is right. We have
Definitely.
deemed it to be served because of the presumption that nobody has appeared.
Nobody has-
Paper publication.
25th March.
Anybody.
We will say, we will indicate.
His or her place of residence.
We
You
have
look at
located- we were told that he perhaps is working in Delhi. So perhaps in one paper in
Where is
Delhi.
the residence?
Uh,
That is, he's giving you
he
nature.
was from Patna, if I'm not mistaken. Let me just we'll check it up. So Haryana, I'm
लिखा
looking
देना।
from Haryana. Haryana.
इनसे लिखा लेना. Yes.
Bibliography.
Item 12,
ये बहुत भारी है ना, इसको आराम से सुनो. इसको आराम से देखो. Yes, sir, you will have to recount the facts. We have forgotten now. We have forgotten.
Once learned senior is done, my lord, I just need 5 minutes to add on, my lord.
In this matter,
In this, once learned senior is done, my lord, after.
now NIOS.
NIOS. I
Okay,
argued for the
you are
learned,
appearing in this matter also. All right.
I had the occasion to assist the learned single judge in this matter, my lord, so. Just something, 5 minutes to add on.
No time limits. As long as you are making sense to us, we will hear you.
From
Yeah.
state side, learned as you लिखने मतलब you like चीनी part है better.
He has to be here, no? Tomorrow?
I can start by the time if he reaches.
That is okay?
Yes, others okay for me, madam. I
No, no, he will come after.
will-
What is the matter that he is arguing? Will it take time?
It will take time. Go in court number 9, madam. ये करेंगे.
Tomorrow.
Yes, Mr. Chaudhary, you tell us.
Tomorrow, because I am be difficult.
You care. It is your today present, AG is not present, so choice of date lies on you. You tell us. Any day, any week, any month, comfortable.
Second.
Well,
Second
can
of
I-
March.
well,
Second of March would be very difficult. No, last day of one judge to retire and all that. She will be sitting with me probably for few minutes. Second is difficult. Ask for any date from 9th of March.
Can I make a suggestion if my lord would permit?
Yes.
Well, can we at least begin? Let the learned AG come post lunch, my lord. We'll at
No.
least for 1.5 hours, my lord.
No,
Because
no,
the
no,
matter
no.
has been pending, and then the same thing will come to the recruitment is over, and now what can be done?
No. That Mr. Kalra would not be a problem.
Thursday.
On 12.
Coming Thursday.
Coming Thursday.
Coming Thursday we can hear.
Very well.
And my lord, the learned AG will give priority to court number 1. Then on that day also there will be matters.
No, all advocates give priority to court number 1, including Mr. Chaudhary. There is no difficulty. But you can't dispense with your responsibility only with court number 1.
It's including Mr. Kalra.
Including Mr. Kalra, they can't. They can't. You see, many a times, when I was a lawyer and I had a matter before the Chief Justice's court, which more often than not was such matter where I knew that it would be dismissed, some uphill task for a lawyer. And it was more profitable to do some matters, interlocutory matters in the other courts. Who would go before the Chief's court? But Chief Justices, successive Chief Justices.
There is some urgency.
Yes, sir,
That's why
yes,
we are saying.
yes, sir, बात ये बोलते हैं.
Because appointments are hovering over our head.
Normally,
I'll take over here. Sir. People are also.
we are aware of many things, Mr. Chaudhary. We are aware of many things. I mean, if it is urgent, we don't know what the provisions. If it is urgent, we don't know what the provisions what the providence has in store for us. So we don't know, but normally it should be heard on that day. All right.
Grateful,
much.
deeply grateful.
As for the non-availability of the learned advocate general who is addressing this court in this matter presently, let this case be listed under the appropriate, let these set of cases be listed on 12th of March in priority.
Deeply grateful, ma'am.
For hearing item 13,
बंद कर दे, चल दिए। हम यहाँ ऐसे बात करते हैं बंद कर। केस के बारे में जहाँ हम बात करते हैं बंद कर। हम ऐसे इशारा भी कर देंगे, ऐसे किया तो मैंने बता। Yes.
Yes, my lord, on the last occasion, we sought time for some instruction.
क्या केस क्या था? What was the case?
This is a PIL
Yes.
with regard to issuance of ration card for the marginalized community in the 3 districts of Arunachal Pradesh. And mainly Pakumpare, Changlang and Namsai district, lordship, these 3 districts.
Ration card.
Ration card.
Now, have they prevented ration card from being given to people in these districts?
They were not being issued. Lordship.
No, that is your complaint.
No.
Have they come up with any classification that no, you shouldn't be given
Yes,
something like that?
lordship. That notification I have annexed along with.
What is that notification?
Yeah.
So question that.
That
Denial of ration cards to communities.
yes.
There is a circular of 1991.
Yes, lordship.
What is that?
Page 121.
Page 121.
Yes, lordship. This is the type copy. This is to inform that all concerned.
No, page 121 is a circular dated 31st of October 1991.
Yes, lordship.
Yes.
This is a type copy. And this says that with regard to the sign.
It is to inform that all concerned that the issue of ration cards to refugees like Chakma, Hajong, Tibetans has been banned by the government. So they are not citizens. They have to be deported back.
Lordship, they are citizens. Their names are being enrolled in the.
No, but this is still on record.
Yes, and no ration card has been issued to, and not only Chakmas. Lordship. As per.
No, but what do you have to say to this, Mr. Chandran?
Lordship, actually, this petition was filed during the height of the COVID, Lordship. And the petitioner, they had.
Mr. Chandran, let us not remind ourselves of COVID. Now 5 years have passed by. Please forget it. What is your instruction today?
Lordship, my instruction is that as the central government is yet to recognize them, to bring them under the NFSA Act, Lordship, where the non-citizens are not eligible to be issued ration.
No. Have you decided that they are non-citizens?
Lordship, it's as per the central government.
As per the central government, you have to say how come? Where is your affidavit?
Lordship,
Where is your affidavit?
Lordship.
Don't make oral statements, Mr. Chandran. See, there has to be a justification for this ban. We will examine that justification, just that. Where is your affidavit, Mr. Chandran?
Lordship, it's filed on Lordship 25/2022, Lordship.
25?
20th of May 22, Lordship.
No. You said on 27th of January 2026. Mr. Chandran, that's not done. Mr. H. Chandran, learned senior government advocate for the state, and submits that rejoinder affidavit of the petitioner has been communicated to the government for this response, but no communication from that end has yet been received.
That communication I have received, Lordship.
That instruction you have received?
Lordship.
Where is that?
Lordship, this is the.
Why are you referring to something which you filed in 2022 in the year 2026? Then you don't prepare, you have not prepared. You're hunting for those papers. Yeah, affidavit hai.
Lordship, they have.
This is instruction. How can you pass it on to us?
Lordship, this was the paragraph which they have, as it has fallen from Lordship last time that.
Why should you do this? You bring it on record, no? Incorporate. She can also respond later. I mean, no reply to a reply, but then you tell us.
It was fallen from your Lordship last time that further evidence should be filed. That's why I have.
But you can't show this to us, can you? Though we have forced you to give it to us, but put it on affidavit. Again, Mr. Chandran. and senior government advocate for the state of Arunachal Pradesh, submits that the response of the government rejoinder affidavit of the petitioner shall be put on record by the next date, re-notify 2 weeks. But let me tell you, will not be satisfied by what paragraphs you have got. That's useless. Some clerk in the department has given you the paragraph. Don't do this business, especially when you file affidavit here. At least find out, talk to the person, make a good justification, otherwise we'll quash it straight away.
27 March. Item 15.
Update there. No, he'll not be able to do it. 1st of April. First week of April. Please do it. We will remember.
8th of April. Item 15.
ठीक है इसको कोई लिखा हुआ था इसमें गलती से एडजर्नमेंट तो नहीं पढ़ा. Yes. Louder sir.
By this petition, I have challenged the rule 12 and 13 of the
Rule 12 and 13 of what?
Assam Higher Secondary Education Provincial Rules 2018. Education.
On what ground have you challenged it?
12 and 13, my lord. Regarding
On what grounds? What are the rules? What are the grounds of challenge?
my lord.
बद्दू सो जजमेंट यहाँ पर दिए हुए क्या है?
First time I page 50, my lord.
दीजिए
70,
वो rules दीजिए.
Page 70, my lord.
Assam Secondary School. Have you quoted it?
Quoted, my lord. I have an
Page?
Page 70, 70.
It starts in is 50.
Page 69, my lord, regarding my lord, the promotion of high speed headmaster, my lord. High speed Shiva.
Hmm. 12, क्या कहता है? 12 and 13.
12 and 13.
12 begins at 67.
67.
पढ़िए.
And my lord, for the first time, my lord, kindly see my lord, page 70, my lord, 70, my lord. Regarding my lord, promotion to the post of high speed.
No, we don't know. You read 12 in its entirety.
My lord. 12, my lord. Page 67. The post of principal in provincial higher secondary schools shall be filled up by direct recruitment from the candidate among the cadre of the postgraduate teachers of senior secondary and higher secondary schools and graduate teacher of higher secondary schools as per procedure under sub rule 5. The post of principal in provincial senior secondary school shall be filled up by direct recruitment from the candidates among the cadre of the postgraduate teachers of senior secondary and higher secondary schools as per procedure under sub rule 5. Explanation: the senior secondary and higher secondary schools shall include any senior secondary and higher secondary schools in the state. The minimum qualification for appointment to the post of principal in higher secondary school and senior secondary school shall be as follows. Number 1, the
All right, we have read that. So which is the offending provision here?
offending provincial malot, initially we are malot appointed as in the malot LP school teacher malot. Subsequently malot, as per scheme.
LP stations and
LP क्या हुआ? Lower primary. हाँ.
So ये school को सब immediately कर
हाँ.
In the amalgamation, they say that you have your senior gainer for promotion protected, but subsequently by this rule they are ousted from this qualification.
नहीं
They teach here.
but the qualification is not, they must be MA. That's across the board.
Across the board.
हाँ.
But their entry level जब वो लोग school में
उससे क्या होता है?
So basically amalgam by virtue of an scheme of amalgamation and the rules they were merged with the school. So now this is our all promotion is otherwise in that.
इसमें ही गलत कहाँ हो गया?
We have to change that scheme and require I think salons and such people also in earlier litigation not this.
These rules have been challenged earlier.
Malot, no malot.
No, that scheme was salon amalgamation.
No malot. No amalgamation.
So what can be done? Amalgamation brings you, I mean, it dissolves you. in that category.
You
How
are
is that?
claiming your right based on your earlier entry in the independent school. Now it was amalgamated. You are part of a higher secondary school. How can you be promoted to a principal without having that qualification?
So therefore, if your prayer is to be allowed, just a minute, Mr. Counsel, if your prayer is to be allowed, this very decision of amalgamating lower primary schools with higher secondary schools has to go. Have you questioned that? So then, useless. Useless petition then.
Now, regarding amalgamation in rule 13 it is stated and if page 70, page 70
Page 70.
70
Hmm.
to 13 subclause 2E in case of higher secondary school having amalgamation with LP school, the teacher of arts world LP school having requisite qualification of and 20 years of teaching experience in both.
Wonderful. This takes care of the offending of which you say is offending. This takes care.
Subsequently,
There is a qualification. The selection shall be based on satisfactory ACR for at least 3 consecutive years and seniority of service in graduate scale of pay. So what is so bad about?
in the graduate scale of pay. Here the LP school teacher but I am receiving the undergraduate scale but both clause are contradictory 2E and 3
सब भी नहीं हो सकता ना amalgamation chance कर देता हूँ एक मिनट ऐसा स्टाइपेंडरी टीचर्स है
Initially, subsequently, they are regular. They are teachers.
Okay.
Initially, stipendary for 1 year. After completion of their training, they become regular assistant teacher. But their scale of pay is not graduate scale of pay.
Okay.
They may be graduate, they may be master degree.
But वो नहीं मिलेगा.
But scale is not there. So now they are scale of pay, granting scale of pay to be the criteria for date of seniority.
Okay.
It's not that they are not compelling, but they are criteria is graduate scale of pay. And graduate scale of pay are granted to the secondary teachers, not the primary. So they are otherwise out of the scheme. Though there is an LP skill provision under E is given. So they are, according to them, scale of they should not be the criteria of determining our seniority because this is an impossible condition we have never been granted. That is okay. Maintain the qualification means that they will LP school teacher. Maintain the 20 years. Regularly considered because we never get scale of pay.
Yes, Mr. Khatniar, what do you have to say to this? That provision, the claim is that it offends Article 14 and 16.
Their entry to the service, they are initially in the intermediate scale.
No. That we have followed, but they will never have that compulsory, that graduate scale.
Yes.
And then you are linking it with 20 years of experience. So aren't you shutting them out?
No, if they have the requisite qualification, then we will definitely consider.
No, but 13 says something else.
Qualification. MABL.
Where is your response?
We have filed our response.
They have filed.
Yes, it was.
Page 100.
On 20.
Page 94.
This one. People they are having not qualification but not stable. Who's conducted it is a convenient and therefore intermediate.
Violation of fundamental rights. Look at your response in paragraph 4 of your affidavit. What do you say? They have raised a specific plea that because of that condition, which is an essential condition of pay and 20 years, linking it to 20 years, that is very, very restrictive so far as they are concerned, and therefore 14 and 16. So you say that they have not said, who is suggesting lack of legislative competence? Not at all. Violation of that right. Equality does not mean across the board. They are a different class. You have amalgamated them there. That they don't challenge. You please keep them.
They have been.
But 13, you must, 13, clause number 13 of the rules, you must suitably amend. Otherwise, they are lost. They have not, they can't have anything.
They are basically this person. Otherwise, he will become obvious. No, this will be.
No, we are not satisfied with your affidavit. Otherwise, we need to. Seniority of service and graduate scale of pay. नहीं होगा ना?
Those are seniority, suppose if somebody is not having graduate scale of pay, then also he might be 20 years having teaching experience. He might be MA, BEd like this person. But they are excluded because of the scale of pay. Whereas E protects their right so that they can also be considered. They come within the consideration under E, but E is made redundant by 3. Because this teacher never gets graduate scale of pay. He may be graduate.
Just a minute. In case of a higher secondary school having amalgamation with LP school, the teacher of first 12 having requisite qualification, वो तो 12 में हो गया, and 20 years of teaching experience in both LP and amalgamated, दोनों मिलाकर उसमें may be eligible for selection. The selection shall be based on satisfactory annual for the last because seniority in service and graduate scale of pay. No, this no. So therefore, this E operates in that sphere only. For them, this shall not operate. ऐसा करते?
ऐसा हो सकता है. Because they will never.
No, it can be made to work to the advantage of these people also. You can always say, I mean, you have not applied your mind. That's the whole difficulty. While defending the challenge, you have not applied your mind. I mean, you means your department. But you just don't pass on to us what the undersecretaries of the department give you. You're here for our convenience also, no? Not only for representing. Now look at this. Now don't question. You have not even considered this. It's not some difficult proposition that we are suggesting. For protecting these amalgamated teachers of lower primary school, come to page 70. E. In case of a higher secondary school having amalgamation with LP school, the teacher of erstwhile LP school having requisite qualification and 20 years of teaching experience in both LP and amalgamated. They don't say how many years of amalgamated school or how many years of LP. So if they have
Composite certificate.
out of 20, they have 17 in lower primary, okay, there's no problem. Teaching experience may also be eligible for selection as vice principal. Now, this is only with respect to higher secondary. Now, 3, selection shall be based on satisfactory annual confidential report for last 3 consecutive years. Good. There is no problem. Seniority of service in graduate pay scale as per procedure provided under sub rule, then they are completely excluded. They will not have. They never got that salary. They got it later. So E is rendered meaningless. You can always say that this would not govern the case of teachers of erstwhile LP school. Finished. This condition will not apply to this. You apply your mind and tell the department, no. Otherwise, we direct for it. But, we are slightly loath in legislating. You have only taken the plea that the subordinate legislation, it has the powers, this, that. I mean, technical, not even technical, those stayed regular paragraphs which you find in all affidavits. That is not the way in which we function.
In fact, we have a similar challenge to this rule, madam, and in some of them we have filed affidavit also disclosing ours there. So, madam may fix it in another day, so I can find it out whether we have answered we have answered this or not, madam. If it is not answered, my lord, I will file a proper application.
Hmm. Take that. What is your name? Huh? Yeah. Mr. So we have heard Mr. So learned advocate for the petitioners, and Mr. Khatniyar for the education department. The petitioners have challenged rules 12 and 13 of the Assam Secondary Education Provincialized Schools Service Rules 2018, which govern the recruitment and promotion to the post of principal and vice principal in provincialized school. Their grievance stems from the amalgamation of their LP schools. The grievance stems from the amalgamation of the LP schools in which the petitioners had been working with higher level schools, which is high schools and higher secondary schools. The government of Assam's Shiksha Kshetra scheme, introduced in 2016 and modified in the year 2021. This scheme, which has never been questioned, informed to us, aims to merge schools for better educational infrastructure. For the sake of completeness, rules 12 and 13 of the service rules of 2018, pura likh dena, Assam Secondary Education of 2018, is being extracted here for a proper appreciation of the contention of the petitioners. The next, usko kar dena. The petitioners were appointed as stipendiary teachers in LP schools in 1993 and 1999 respectively. After selection, training and confirmation, their services were regularized and they started receiving pay scales of assistant teachers. Later, as noted above, under the Shiksha Kshetra scheme, the schools in which the petitioners were appointed got amalgamated to higher schools, requiring the petitioners to teach up to class 11 and 12, such higher secondary schools. But they continue to be paid only the intermediate pay scales meant for LP teachers. The contention of the petitioner is that 2018 rules, especially section 13, do not adequately account for teachers like the petitioners, namely former lower primary school teachers who got integrated into secondary/higher secondary systems. Rule 12 requires 17 years of experience as a graduate teacher for the post of principal, but defines graduate teachers as those with graduate qualifications appointed in higher schools, excluding LP teachers whose minimum qualification was HSLC. Similarly, Rule 13 for the vice principal requires 20 years of teaching experience, which would be inclusive of the experience in LP and amalgamated schools. But the rules prioritize seniority in graduate pay scale, which LP teachers like petitioners lack. To that extent, Mr. So learned advocate for the petitioner submits that the rules are discriminatory, they create discrepancies and deprive them of the promotional opportunities despite their long service and their qualification. Despite their long service, their qualification and their qualification and their current duties in the higher secondary system of education. The affidavit of the state does not address the present issue, but only harps on, but does not address the issue. Mr. Khatniar, learned standing counsel, learned standing counsel for senior standing, whatever, learned so and so for the education department, has submitted that this subordinate legislation was enacted was within the powers of such legislation, and that it does not adversely affect any one of the fundamental rights of the petitioners. A very blinkered argument has been advanced on behalf of the state. Realizing this, Mr. Khatniar, learned advocate for the state, submits that he shall examine the matter afresh, hold consultations with the department, look at the response of the state in other writ petitions challenging the rules, and shall then come back to this court with a comprehensive reply. Let that be done positively by the next date. Re-notify on so and so date. May.
5th May.
Now we have framed the issues now. Total issue has been framed now. You answer that. Very simple. You can make 13(3) only not applicable to LP teachers. Finished. Nothing is required to be changed. One addendum. That way it saves your entire act.
In principle, this is a deliberation. He can be excluded, no problem.
Only promotion.
Not
Think about it. Only promotion. 14 goes for, that is compromised for us there. We'll come back after 5 minutes. What is the next matter? बहुत अच्छा है, हमको काम है, पढ़ना होना है.
administrative change.
Yes.
Item 17.
But this PI basically challenges the notification is page 27, right?
Page 27.
27. Whereby there are 5 villages in the Kachha district now, namely Dudhpur Part 2, Mahadevpur, Bonigram Part 1, Part 3, and Sripur Part 2. So these villages have been brought under the administrative control of the Hailakandi district from the Kachha district, and on the ground of better law and order maintenance, communication with general governance of public, as well as to ensure better public service delivery system. So we are agreed by this in as much as these villages are basically within the Kachha district, have got no attachment to Hailakandi district. So this was basically done, my lord,
Because there is a notification with regard to the delimitation matter, that page 92, the additional affidavit. Now, that is an affidavit was filed, additional affidavit. That was filed on
Page 92.
page 92, my lord. If the running page is correct, it's from the date 92, it should be 92.
No, date.
Date, my lord.
18-1.
Affidavit was filed on March 2023, my lord.
23.
Yes, March.
First of February.
No. 27th of December 2022. Press note.
Press note, my lord.
Page 92, annexion 9.
My lord, this, my lord,
Hmm.
before the delimitation exercise started, my lord, this, my lord.
Just a minute, let my brother
My-
come to it.
my- Page,
Page
annexion 9,
92,
page 92.
Yeah.
What he did, my lord, before the start of the delimitation process, my lord, from 1st of January 2023.
No, just a minute. Read the top line. ECI initiates delimitation of assembly and parliamentary constituencies under section 8A of the RP Act.
Okay.
Yes.
Then
And the census figures of 2001 to be used for the purposes of readjustment of ACs. क्या हुआ? What are ACs?
AC parliamentary constitution, legislative.
Assembly and parliamentary.
Constitution, parliament.
Ban on creation of new administrative units in the state.
With effect from 1st of January 2023.
Hmm.
Now just on eve of it, my lord,
Hmm.
just when it was not just to take effect, my lord.
No, read the
Yes,
press
sir.
note.
In pursuance to the request of the Ministry of Law and Justice, Government of India,
Hmm.
Election Commission of India has decided to initiate the delimitation exercise of Assembly and Parliamentary Constitution in the state of Assam as per section 8A of the Representation of People
RPA,
Act 1950.
Representation of People's Act.
The commission led by Chief Commission, Election Commissioner, so-and-so, and Election Commissioner, so-and-so, has directed the Chief Electoral Officer of Assam to take up the matter with the state government issued a complete ban on creation of new administrative units with effect from 1st of January 2023 till the completion of the delimitation exercise in the Assam, in the state. As mandated under Article 170 of the Constitution, census figures 2001 shall be used for the purpose of readjusting the parliamentary and assembly constituencies in the state. Reservation of seats for the scheduled castes and scheduled tribes will be provided as per Article 330 and 330 of the Constitution of India. The Commission will design and finalize its own guidelines and methodology for the purpose of delimiting the constituencies. During the delimitation exercise, the Commission will keep in mind the physical features, this is relevant, the existing boundaries of administrative units, facility for communication, public convenience, and as far as practicable, the constituencies shall be kept in a geographical compact area. Once the draft proposal of delimitation of constituencies of the state of Assam is finalized by the Commission, it shall be published in the central and state gazettes for inviting suggestions, objections from the general public. In this regard, the notice will also be published in two vernaculars newspapers.
No, has it been gazetted?
That has been done, madam. That has been done.
You have given your objection.
No, we have not challenged that, madam, because
Have you given your objection?
yes, we have given up.
So what challenge? You have challenged it.
No, this we have not challenged here, madam. We have basically challenged this notification which came.
No. So this is over.
So this is what I'm trying to show, madam, is that this notification of 20.
After the draft note was published,
Yes.
has it been gazetted?
Yes, madam, this is getting.
So this is nothing.
No,
You have
no,
challenged-
we are basically, we have not challenged this, but that's what I'm saying. Ideally, perhaps our challenge would have.
Withdraw this, challenge that.
Well,
Additionally, we will not permit you.
No, madam. I'm not, I've got nothing to do with this delimitation, madam.
There may be delimitation,
Hmm.
but administration of this still remains within district of Patna.
Okay.
Two first, two
No, it can't be.
that is not complete. One is so far relating to assembly constituency. In an assembly constituency, it may be a village, may be within an assembly constituency, but district remains the same. It is assembly is not as per district. So their district is the jurisdiction of Pachai. Now they are being now governed by
Hailakandi.
Hailakandi. But it is in the delimitation of constituencies, not of the change of boundary in district.
Okay, agreed. So
So
the
that-
purpose is only for that, no?
So therefore he is not challenging this. There is nothing.
What does he want?
He is challenging only rule 6, annex of case 27.
27.
Saying
How-
that we are under district, so we are supposed to go to that district which do not have any jurisdiction. That is his case.
तो और गलत हो गया ना.
This is administrative jurisdiction. The only question is whether they are within the administrative majesty of others. That's all.
Yeah, but this is not challenge, no?
This is the challenge.
So this is no challenge. This cannot be. Notification or challenge.
What is your prayer in this report?
Prayer is for setting aside this matter because this
Setting
was,
aside annexure 6 page 27.
yes, because it affects our day-to-day lives, matter. Apart from the Lord, what happens with the constituency delimitation matter? That's another issue as per the matter.
No, so it goes to which district? Administrative district after change would be Hailakandi.
But district is not notified.
Administrative district apna ho gaya, district it will fall in Hailakandi only. I don't think this is an objection. Just a minute, एक second. Let me just take that. इनके hardships हमें देखना है ना.
So therefore you are under now district of Hailakandi.
Administrative control of Hailakandi, whereas we are situated deep within Kasha district.
No, maybe, but
Mr.
you are on.
Yes,
Datta, can you deep within or on the fringes? That is not a question because you have not challenged this taking away this delimitation exercise.
Good submission to Lordship, Madam. Ideally, perhaps it ought to be challenged, but my submission is apart from this.
Forget about ideal situation.
Irrespective of this.
But what do you want actually?
Our case is that this particular notification has made things difficult for us because the
That's all right. Hardship is no ground. What do you want? That it should again go back to Kachar? Just tell me yes or no. Don't give explanation. You want it to be taken away from Hailakandi and to go to Kachar.
This should be under.
Therefore, the challenge only would have had been with the delimitation exercise that geographical blockchain has not been maintained. Difficulties have not been. What are you
What has
talking?
happened, in fact,
I don't think this is not getting inside my head. Maybe I'm not understanding what you're asking.
What has happened? Another just example. What has happened? Some districts.
So forget about that. You say that this notification of annexure 6
Yes.
is issued without jurisdiction or
No.
without boundary, without declaring the separate district. This is your case.
This is.
If not, then they
No,
have
this is-
their
this-
power to change this.
They have.
The whole purpose of changing, the whole purpose of limitation was to take these villages away from Kachar and attach it with Hailakandi. Now you are not challenging that delimitation process. You are asking that let it go. Then let it go.
Delimitation cannot be linked with this. Even suppose there are two
Suppose,
districts.
whatever,
Huh.
two districts of which.
Constituency-
But under the administrative control, it has gone to Hailakandi.
What happens, my lord, in this case, my lord, this is supposed to be for better
I am
law
not able to
administration.
get, I mean,
What
you
happens,
you may be suffering hardships.
No, that is-
What happens, my lord, tomorrow if there is if tomorrow, my lord, there is a natural disaster, my lord, it creates havoc.
That is hardship.
So
Can
these
we
are-
replace our views with the views of the
No,
administration?
my lord, my humble submission is this, my lord, this was done arbitrarily, my lord, whatever grounds they've taken for better public law and order.
Any
implementation.
procedure prescribed for doing this?
My lord, there is nothing else.
Then-
There is nothing. That is there. That was there. But then, my lord, they have to take public convenience also into account, my lord, because this district, my lord, are formed, my lord, for public conveniences, my lord. My lord, a
Now,
person.
what will be the headquarter of those Hailakandi? Hailakandi.
Hailakandi.
And how far would you be from Kachar
My lord,
headquarters?
the Kachar district, my lord, I have given a chart, my lord. It was around, my lord, my lord, our district headquarters are around, my lord, average 18 kilometers. Now it's come to 40 kilometers.
No,
distance.
30 kilometers.
And there are, my lord, in between, my lord, several other villages which have not been picked up. We have been picked up from middle and, my lord, attached to the
Is it
highway.
unusual?
Unusual, my lord.
No. No.
Normally, my lord, what happens?
My village home is very close to Darbhanga district.
Right.
But it has, in delimitation, it has fallen in Madhubani district.
Well, so far the delimitation part, that's what I'm saying. So far delimitation part is.
And the village next to mine is in Darbhanga.
What I'm trying.
That I'm talking about two districts
What I'm
there.
trying to have this submit
That
with
is
that.
not his.
Well, so far as the delimitation part is concerned, that's another exercise. Of course. That affects my.
Impossible.
Right.
Impossible. Otherwise, the annexure name, we cannot insert there. This is the.
मैंने election नहीं कम वो लेके नहीं कर सकता ना वो that your नहीं हो सकता. Let us see what Mr. Nayak has said. I don't think this prayer is tenable. Have you said so?
Lots of, in fact, yes, in my affidavit, in fact.
Where do we find your affidavit? It's not tenable at all.
Affidavit by one Satyajiti Burwa, Lordship.
No, give us the page number.
94. Respondent number 2.
Yeah.
एक second.
Hearing Lordship, in paragraph 4, I have stated that a proposal was received from.
Just a minute. बेकार एप्रूव किया है, बहुत बेकार एप्रूव। कुछ नहीं है, कुछ भी नहीं। He has challenged page 20, 92 and page 26. Man, this is a sequel, no? This is a sequel.
No, sir, it is not sequel.
Lordship,
See, it is an independent exercise than the delimitation. There is no relation between this and delimitation. This is they are having this power to do this, to change the jurisdiction of administrative district. Under a constituency, when purpose of legislative assemblies.
Just a minute, ये तो नहीं है. It is decided to initiate the delimitation exercise of some kind.
So delimitation will not be in कोई जरूरी नहीं है. ये अगर कासार में भी रहता है, तो भी delimitation हो सकता है. Because it's a constituency.
That's all right, but it is under this request. Look at the press note. But why do we get into this? Delimitation or?
कोई जरूरत ही नहीं.
Take on, I'll take it as delimitation.
But page 96, they give the reasons why they did this. Now, this is totally.
No, sir, just for my clarification, two concepts. One is delimitation
Yes.
and other is administrative control of a district,
Yes.
Kasar and Hailakandi.
Yes.
There may be a constituency which covers and after delimitation, both Kasar district and Hailakandi.
Right.
So delimitation is for a different purpose. For this is the purpose for proper administrative convenience.
Exactly.
You say this is not convenient, they say this is convenient after exercise.
Brother,
Difference there.
delimitation is
True,
not
brother.
necessarily for creating any additional district. It is only addition of few districts to a particular constituency which need not tally with the administrative unit or district. It's a constituency. So whether it is delimitation or general power, but it is under for delimitation. This is the press note.
But otherwise it violates the delimitation norms.
But
It doesn't,
That's
it doesn't,
That's
it
why I'm
doesn't.
not arguing on this one. But then, my humble submission is.
Entire process was
the
initiated by
reason
virtue of
for
this
which.
press note. It is delimitation only,
Yeah.
which may not necessarily be, but delimitation के process में है, and the purpose is, will tell, existing boundaries of administrative units, facility of communication, public convenience, as far as practicable, constituencies will be kept as geographically compact. Personal hardship is
No, I mean,
nothing.
This one challenge in many reputations, all these delimitations are upheld.
Take note.
In fact, after some districts there was a march. Then after the delimitation process, there again, new districts were
That
created.
is what a
So
purpose.
here perhaps,
We have heard Mr. M. Datta, a learned advocate for the petitioners. How many of you?
five.
just one submission, Lordship. Lordship has seen the affidavit.
No, we are dismissing this petition. What argument you are arguing?
Now, moreover, Lordship, out of the 5 petitioners, Lordship, 2 are not connected with the villages at all. Only 3 are the.
No, 2 are not connected with PIL. You want us to discuss first whether these are
I-
petitioners whose locus could be questioned. No, but it doesn't matter. Even if we delete them from the area of the parties, it is not my. Mr. Datta's arguments have not convinced us. His pleadings have not convinced us. We have heard you should have, Mr. Naik, you should have written something else. You should have said that this is pursuant to delimitation exercise.
Lordship, delimitation has not even been questioned. It's a
That is
notification.
what I'm saying, no.
already seen.
Delimitation exercise has been done. That has not been challenged. Therefore, this placement of 5 villages in that district for our reasons, for the reasons that you ascribe,
Lordship, in fact, Lordship, on the same date, several notifications were issued in respect of.
आप
some
बात ही नहीं समझ रहे हैं नायक साहब
Lordship,
आपको
in
मैं क्या
respect-
कर रहा हूँ try and
Just,
understand
just, why?
when you file the affidavit you should state all this, that is what I am saying.
No, why we have not mentioned Lordship, in respect of those villages also, several PILs were there. And those PILs were decided, asking the petitioner to approach the district commissioner or before the delimitation.
But
commission.
does it mean that you will not state this in your affidavit?
That came subsequently. Lordship. That-
अभी आप एक 2-page note आप बना देते. These are the reasons. You know, see, apart from holding brief for the state, you also have to facilitate us, no?
But as the delimitation is over now, only option.
Doesn't know. Now he will, you are suggesting him the ways. He will now tailor his argument and say that now with the delimitation exercise, you let it remain in the same constituency, but headquarters would be there.
But that process is also over. The delimitation process is already over.
Anyway, we are dismissing this PIL. If that satisfies you, Mr. Nayak, okay. We are telling something else. You are perhaps not catching on to what we are saying. We are dismissing this PIL.
For the purpose of now we restore this.
The moment you take that plea, he will tailor his argument now.
But
Don't
he
take that
already
plea.
submitted that we are not.
Take the plea that this is by virtue of this delimitation, which is over, number one. Number two, even if it were not over, it was only a press note or a decision-making process. No ground has been made out, just personal hardships. That is the end of the matter.
Yes.
Now, instead of filing an FIR in Kachar, they have to go to, say, 30 kilometers to Hailakandi to file FIR.
Lordship.
He doesn't know that with respect to this, nothing, I mean, there will be no change. It will depend upon the police station under which this village would fall.
Lordship, in-
All spurious, reasons have been given. You have to counter that.
Yes, Lordship, in
Just-
fact, this is a policy decision taken.
Everything hindsight you say, but not while filing affidavit.
Affidavit. Affidavit.
So, take them. We have heard Sri M. Datta, learned advocate for the petitioners, and Mr. P. Nayak, learned additional advocate general Assam, for learned advocate for respond number for the learned advocate general Assam, learned advocate general for the state of Assam, who appears for ECI, Mr. Mr. A.I. Ali for the Election Commission of India, and M.S. Boda for assisted P. Nayak, assisted by M.S. Boda. The petitioners are citizens from Kachar district in Assam who have questioned the correctness of the decision of the government in transferring 5 villages, namely so and so, 5 villages, namely Dudhpur, part 2, Mahadevpur, bracket Mohanpur, Gonigram, part 1, Gonigram, part 3, and Sirpur, part 2. You will get it from page 27. Huh? What did I say? Before the names? So and so, from Kachar district to Hailakandi district, by virtue of a notification dated 31st of December 2022. Against the claim of the government that this transfer of villages to another administrative unit in the district of Hailakandi was made for better law and order, easier communication, and better public services. The petitioners claim volubly claim that such transfer would actually cause huge practical problems and hardships to common people residing in those villages. Most of the residents of the village are poor farmers or daily wage workers and petty businessmen who depend on public transport and government offices in Silchar, which is the Kachar headquarters and nearby facilities. With this transfer of the aforementioned 5 villages to the district of Hailakandi, the apprehension of the petitioners is that the villagers will have to travel longer distances to reach the collector's office, to reach either the police station or the collector's office or education block or revenue circle office, etc. While doing so, they would have to cross Barak River. There is no chain of communication from these villages to the headquarters at Hailakandi. The other contention raised on behalf of the petitioners is that while undertaking this delimitation exercise, for no good reason, for no good explicable grounds, were these villages chosen, leaving other contiguous / neighboring villages which could have formed chain with the villages already falling in Hailakandi district. The villages which are in geographical propinquity to the district of Hailakandi have been left unchanged, have been left untransferred. The petitioners therefore, Mr. Datta therefore contends that such decision to transfer the aforementioned villages to Hailakandi district is arbitrary, not based on any proper study or of any consultation. They had held peaceful protests, but it all went on deaf ears. Mr. Nayak, learned Additional Advocate General Assam, however, submits that this notification under challenge is by virtue of a decision taken on the ECI initiative of delimitation of assembly and parliamentary constituencies in the state of Assam, as provided under Section 8A of the Representation of Peoples Act 1950. Keeping the census figures of 2001 as the basis for readjustment of various constituencies. To conclude the exercise, the Election Commission designed and finalized its own guidelines and methodology for delimiting the constituencies. While undertaking that exercise, the Commission was conscious of the physical features, the existing boundaries of administrative units, facility of communication, public convenience, and as far as practicable, the constituencies to be kept as geographically compact area. A draft proposal also was Inviting suggestions and objections from the general public. And only thereafter such delimitation exercise was carried out. Next. The sum and substance of the argument on behalf of the state, countering the assertion of the petitioners, is that once the delimitation exercise was initiated and a proposed adjustment was published inviting objections, whereafter the delimitation exercise was notified, thereafter the delimitation was notified, comma, villagers of few of the villages would not have the authority to question such decision of being attached, of their villages being linked to an administrative unit in Hailakandi district, comma, a neighboring district, taking it away from Kachar district. The objection could have been filed or raised at an earlier stage. Mere hardship or mere hardships of few or inconvenience for reaching out to public offices would not be a ground to set at naught a considered decision of the Election Commission along with the central and state government agencies for the purposes of clubbing villages under administrative units, maintaining the geographical compactness of the constituencies. The contention of the petitioners may be true that with the change of the headquarters, where the residents of such villages would now be required to visit, would definitely cause inconvenience. But such inconvenience cannot be the reason for doubting that the commission, along with the central and state agencies, did not consider the relevant factors and calibrated those in account before taking a decision of removing few villages from one district to another district. There does not appear to be any merit in this petition, and therefore the same is dismissed.
None.
Yeah. Yes. Yes.
Item number 14 has been mentioned without seeking our consent. And your lordship has fixed the date 30th of April.
Who mentioned that?
The petitioner.
Who was the advocate?
Lordship.
He said that he has taken consent. He said that he will inform.
Lordship, now it's in.
All right. Are you aggrieved by the date which has been fixed?
Yes. Lordship.
You want a change?
Yes, your lordship.
What change you want?
5th of May. Lordship, can it be on 5th?
And we have fixed what date?
30th of April.
30th April.
So can you just find out that lawyer who had mentioned before whom I had fixed the date?
Sure, lordship.
Come back at 2 with the advocate. We'll have it changed, and we will also pull him up. Why did he not contact? Yes.
Lordship, I called up the counsel for the petitioner. He told that he has already left the court premises.
So have you informed him?
Yes, your lordship.
वो जो item number?
Yes, 14.
Keep it on 5th of May.
5th of May.
5th of May.
Deeply obliged.
Item 19,
Yes.
My lord, in this case, notice inviting tender was issued on 29/11/2023.
What is it? I just didn't hear. What is it?
Yes, my lord, this Indian made foreign liquor tender was issued. My lord, we are the successful bidder. My lord, 6 bidders participated. Out of that, 3 bidders were selected in a technical bid after evaluation. Now, 3 were rejected. Then, my lord, after that part was over, the complaint was received by the district collector that the evaluation is not correct. Then, my lord, the district collector again said for re-scrutiny. In the re-scrutiny, respondent number 1, my lord, was found to be not valid because of certain reasons that has been elaborated.
Respond number 1 here.
In rate appeal.
Huh?
In the rate appeal.
Respond number 1 in the writ appeal.
In this rate appeal, my lord.
In this writ appeal, acha, not in the writ appeal.
In the writ petition, my lord, he challenged, my lord,
Yeah.
only, I'll take your lordship to that at page 31. Learned, single judge has shifted from there. Lordship may kindly see at page 31. This is Rajdeep Rajkua. with the
Page
highest-
31.
Page 31 of the writ appeal.
Yes.
The lordship will find A, Rajdeep Rajkua, H1, the highest bidder. Professional tax clearance certificate.
He's what? He was, he's respond number 1 here.
He is the appellant here.
Hmm.
Now, they have challenged that these person did not comply these 3, number 1 will, your lordship will find professional tax clearance certificate not submitted. Land revenue clearance certificate not submitted. Distance from the state highway not mentioned. Now I'll take your lordship to page 161. Your lordship will find they have submitted the professional tax, which your lordship will find at page 161 and Annexure A. Then page 162, where submitted the revenue from 162 onwards. Then 164, your lordship will find distance from the highway. Lordship may see at page 167, the last, in the top below. From the national highway, 3,000 meters approximately. Now we complied, while we filed it, we have complied with these 3 conditions. Now, without going into all that, your lordship will find the learned single judge while passing the order. I'll take your lordship at page 265. Page 265, I'll read from paragraph 24. This is the observation of the Honorable Court. That this court first take note of the rejection of the petitioner's bid in the.
Paragraph 24.
Para 24 at page 265. That this court first take note of the rejection of the petitioner's bid in WPC 1384/2024 and WPC 1, we are concerned in 1385/2024. Taking into account that the reason for rejection of the petitioner's bid in both the cases are one and the same. From a perusal of the clause, clause 6 of the bid documents, there is no mention that the bank account details along with the proof thereof are required to be submitted. It is only in Annexure A, which is the application form, there is a requirement of proof to be submitted as regards the details of the bank account. From perusal of the application form, which has been enclosed to the writ petition, it is seen the petitioners have duly provided the bank account details, the name of the bank and type of the accounts as well as the account number. In proof of the same, the petitioner have submitted a certificate given by the concerned bank that he is a reputed customer of the said bank. It is also relevant to take note of the clause 6 of the bid document. The authorities concerned have specifically mentioned which are the documents required to be submitted.
It seems taking into account clause 6 of the bid document, the technical bid committee had initially on 13/2/2024 decided that the bids of the petitioner in WPC number so and so were technically valid. Now, this portion your lordship may skip, then we can come to paragraph 27 onwards, maybe,
Yes, sir.
at page 260.
Give 1 second.
Yeah. Lord, this is in regard to 114, my lord, that their contention is that there is an amendment in the excise rule, and once the deed once accepted, that cannot be changed. You know, that is their contention. And page 27, your lordship will find at this stage, I mean, page 267 at paragraph 27. At this stage, if this court duly takes note of the rule 114A of the rule 2016, it would be seen that the financial bids of the technically qualified bidders shall be opened also in presence of the bidders or their authorized representatives. Therefore, a person, entity who had been adjudged to be technically qualified has a valuable right to be considered for the financial bid. Mr. Pathak, the learned counsel appearing on behalf of the excise department, submitted that there is no vested right upon a bidder even after opening of a financial bid. And as such, the petitioner and WPC number so and so had no rights on the basis that they were informed inevitably that their bids were technically qualified. The said proposition in the opinion of these court would hold good in a usual tender process. However, when the grant of Indian made foreign liquor of license is decided on the basis of Rule 114A, which is a statutory rule, a right is conferred upon the bidder after having been adjudged as being technically qualified to be considered for the financial bid as per the clear mandate of clause 5 and 6 of the Rule 114A of the Rules 2016. This court is further of the opinion that if a right is created for the purpose of being considered for the opening of the financial bid, this right can only be taken away after duly providing an opportunity to the bidder to explain the deficiency which came into light subsequently after being initially held to be technically qualified and duly informed to the bidder. The same is required for the reason that the action on the part of the responding authority should also be seen to be fair and transparent while setting state judges and keeping in mind that Rule 114A had been inserted to settle licenses in a fair and transparent manner. It also paramount to observe that fairness and transparency in state dealings are hallmark of Article 14 of the Constitution. In the instant case, what is seen that in spite of the fact the petitioner WPC number so and WPC number so and so were informed that their bids were technically accepted and financial bids to be open on 16 February 2024. But on 22 February 2024, the respondent authorities overturned the said decision, thereby rejecting the petitioner's bid in WPC number so and so. That too on a condition which is not a part of clause 1 of the proceedings. Additionally, the petitioners were never informed of the deficiency which came into light subsequently. Under such circumstances, in the opinion of this court, the impugned actions on the part of the respondent authorities in rejecting the technical bids of the petitioner and WPC number so and so have resulted in arbitrariness, unfairness, and unreasonableness for which,
From
the minutes of the meeting dated so and so, in the backdrop of the above, let this court deal with WPC number so and so. Admittedly, the private respondent hearing, who is also the private respondent number so and so, did not submit the income tax returns as well as the balance sheet for the relevant periods duly certified by the chartered accountant. The learned senior counsel appearing on behalf of the private respondent as well as the counsel appearing on behalf of the respondent authority. Submitted that the same has been held to be.
Appeal file के हैं,
that
राजपूत
will be
राजपूत।
found. However, a conjoint reading of the extracted clause 2 and clause 6 would show that the requirement of
At what stage, I mean, what does the judgment say? Judgment
ultimately-
says the impugned minutes of the technical bid committee dated so and so, so far as reduction of technical bids of this is concerned. क्या नाम है इसका? Gogoi. Prashant Gogoi.
Now, your lordship will find
1 second. Prashant Gogoi is concerned. Unfair. Therefore, is unfair and arbitrary. All consequential actions taken by the impugned minutes of the technical bid so far as of these two are interfered, set aside. As a result of the interference setting aside the decision, the respondent authorities are given liberty to proceed with fresh settlement procedures. From what stage?
my lord, now it's a fresh one, my lord, we have, the price, financial bid was opened, we have paid 31 lakhs and all.
For that, they have given you the permission.
Well-
This direction is from, I mean, from which stage?
They are saying for a fresh,
For technical assessment
for technical.
or fresh tender?
All fresh.
Where it doesn't say so. As a result of the interference and setting aside of the decision, so and so, the respondent authorities are given liberty to proceed with fresh settlement. Fresh means fresh tender.
Fresh tender.
This order was passed when?
Now, this was passed, my lord,
24/9/2024.
well,
Has any fresh tender been issued?
my lord, it has been issued, but they haven't acted.
You have participated. You have applied.
No, I
Why?
did not, because my lord, I had already spent 35 lakhs, I don't have.
No, that will be returned or offset.
What is it?
That is, who appears for the excise department? Whom are you appearing for? Respond number one. Who appears for the
The
excise?
lordship can is what he has challenged. He did not challenge all these things. Only thing, certain documents are not furnished. The lordship has seen that.
Mr. Datta, under Article 226, it can go here and
My
there.
lord, I am conscious of that situation, but then your lordship can see what is my fault here? I have invested.
Nothing. But you were heard.
Beg your pardon.
But you were heard.
Yes.
You were a party, you were heard.
Right.
इसको पता होगा सर whether he has participated.
No, nothing has happened. He has not. Have you participated?
My lord,
Have you?
That instruction I don't.
Instruction. Suppose you had participated. If that is over, then I don't think it calls for any interference.
My lord, my instruction is that my husband has said, he has participated.
Participated and what happened thereafter?
Now it is not, my lord, in the stage, they just stop. There's no progress. Just.
No progress.
Yes.
But why did you not participate?
Lord, I am financially transferred, as a lordship, I have invested here 35 lakhs.
No, that permission, that would have been returned to you. That is no ground.
That happened.
The counsel for the private respondent submits that they have paid certain amounts pursuant. The private respondents would be at liberty to request the respondent authorities for refund. Otherwise also it will be refunded.
But it is burden they haven't, my lord, even.
You ask for it, no? Just a minute. And how do we decide this, Mr. Datta, when the fresh tender process, this order has taken effect?
Others have participated.
Because.
This order has taken effect. Others have participated. Same question, some other advocate will come, what is our fault? Immediately you should have come for a stay. When did you file this appeal? Huh? When did you file this appeal?
There is some order possibly there in the file. In two order.
24th January 2025.
Order का पास हुआ है?
The outcome of this writ appeal. Because of that possibly they are not progressing.
File कब किया है? 10/11/12.
January.
When was the tender issued? Fresh tender? Have you questioned that tender?
No.
Then try and understand. All those who have participated, what will happen? You have just come against that order. Consequently, I mean, you should have also challenged the publish.
File an application, it is pending before the lawsuit.
No, not now. Now people have participated. What is the stays? Tell us. Call the excise law. Which lawyer appears for the excise department?
Mr. Pathak can go.
D Guru. वही वाला.
Last time.
Any counsel for the state?
This is the new council excise.
Mr. Datta, send somebody from your office to inform the lawyer. We are fixing it for tomorrow. We are fixing it for tomorrow. You'll consider this aspect also. You would also like to, if you want to keep it pending, you must file an interlocutory application or bringing in another prayer, modifying the prayer of cancelling that floating of tender and all that. Otherwise, we will not be able to do. You'll have to arraign those persons who have entered. Otherwise, we will not. At presently, we don't think we should enter into.
I could get that.
So take instructions about this. I don't think the better option for you would be that we conclude this writ petition, this appeal, by saying that once you apply before the authorities, they will refund you your amount which you have deposited, and you will be permitted to participate in that tender, in that process, if the results have not been declared, if the technical evaluation has not been done.
Right.
Take instructions, do this. This is the only thing that we can do now.
Yes.
Take
I will
instructions,
get attention.
come back to us tomorrow. We will permit that.
It's a very good idea.
We will permit that. Otherwise, it straight away has to go. This appeal would be dismissed for many others. You may say that we were in the process, but it took time. We don't know. As on date, we can't interfere. You will see.
No, it's from government.
He's a government advocate. Cannot answer. Do you represent the excise department?
No, my lord.
Who represents the excise? Huh?
PN Goswami there.
You inform Mr. Goswami. Additional.
My lord, I listen.
Inform Mr. Goswami.
My lord,
We are keeping this matter tomorrow.
my lord.
Here, we have heard Mr. S. Dattaland, senior advocate for the appellant. So, this case is being adjourned for tomorrow. That is 25th of February. For the reason of, they're being adjourned to enable Mr. P.N. Goswami, learned advocate for the excise department, to inform this court about the stays at which, about whether the fresh tender for giving IMFL off license issued by the excise department has been concluded or it is still pending consideration, and if so, at what stage? Tomorrow and day after tomorrow, kar do, because this order will be done. Day after tomorrow. Take instructions also, Mr. Datta.
Yes.
Or we can even, without your taking instructions, we can say that if so deemed necessary by the appellant, this, no, let you pray for it.
Let instruction come.
Let you pray for it. Otherwise, you have no case presently. We have some doubts about the correctness of the judgment passed by the learned single judge, of course. We have some doubts,